Employers beware. Major changes to employees' duties can invalidate your employment agreement. Earlier this year, the Ontario Court of Appeal issued its decision in Celestini and ShopLogix. In 2005, Mr. Celestini became the Chief Technology Officer at ShopLogix. At that time, he signed an employment agreement that restricted his entitlements in a case of dismissal without cause. However, and in 2008, Mr. Celestini signed an incentive compensation agreement that substantially altered his compensation, increased his workload, and expanded his responsibilities. In 2017, ShopLogix dismissed Mr. Celestini without cause. ShopLogix took the position that Mr. Celestini's rights were governed by an employment contract that was signed 12 years earlier. Conversely, Mr. Celestini argued that by 2017, the termination provisions relied on by ShopLogix had become unenforceable as the substratum of the 2005 contract had disappeared or had been substantially eroded due to material changes in his employment. In the labor and employment context, the change substratum doctrine recognizes that the employment relationship evolves over time, such that it may be inappropriate to rely on the provisions of an outdated employment contract of a job that has changed significantly. In its decision, the Ontario Court of Appeal confirmed the following factors when considering whether the change substratum doctrine applies. First, the doctrine is not limited to non-executive roles. Second, there must be a fundamental expansion, not a reduction, in the employee's duties that engages the doctrine. Third, a formal change in title is not required. And finally, number 4, the question of whether the employee's level of responsibility and corresponding status has escalated so significantly is one of substance and not form. Specifically, it must be determined whether there were actual increases of a fundamental nature in the duties and degree of responsibility of the employee. The court confirmed that the doctrine can be avoided, where employment contracts expressly state that its terms, including termination provisions, continue to apply despite an employee's duties substantially changing over time. This decision serves as a useful reminder for employees to review and revise their employment agreements, especially where there is a significant change to its employees' duties and responsibilities. Contact the employment experts at Perley-Robertson, Hill & McDougall for advice with respect to your company's employment contracts.